Hi, this is Rahul Reddy along with, I'm from REDDY NEUMANN PC. Every Tuesday at 5 p.m. Central Time, REDDY NEUMANN PC brings in immigration news. Today along with me is Hoang. She is the supervising lawyer in our Houston office and she supervises 8 lawyers and a team of approximately around 20 legal assistants. She's very specialized in the H-1B visa. What do we have today, V?
Okay, so today's first topic is delays, denials, and short approvals. So what's the solution?
Yeah, that's one of the things that is bothering now as compared to what it was in the previous administration. This administration, there's been a significant amount of delays in the non-immigrant visa applications and the immigrant visa applications. We have also noticed a significant amount of denials and short approvals. Delays, according to the recent notification by the USCIS, they said that almost double the timings that it is taking for any non-immigrant visas and immigrant visas to be approved. In the denials, especially in the business immigration visas, we have noticed that the denials have gone up by approximately 500%. That means if there was one denial previously, there were 5 denials right now in this administrations. We also noticed that in this administration, it is more shorter approvals. Now, if the H-1B or L-1 is granted for 3 years or 2 years in the respective visas, but they're only granting shorter amount of times. Sometimes we have even noticed that the H-1B approval comes in the month of March, but they only approve until February of 2019, even though we got the approval in March of 2019. What's the solution, V? Now, you are the person who is supervising so many lawyers in the H-1B in our office. What is the solution that you can think about it?
I mean, take it to the courts. You know, nowadays we just have to keep in mind that maybe potentially with every H-1B filing, you could potentially finish this out in court. And so litigation really seems like the only way to combat straight denials or partial denials, which are short approvals. So maybe considering, changing the mind of the change of thought is that maybe the only way to solve it.
Has your team ever taken any of the H-1Bs recently to the court?
We have done one. Currently
many, but one of
them are still currently pending with the courts.
And what happened with that?
That was, I believe that was a short approval. I can't remember the facts very well. It was the same day. The other one was one that was the same day approval and expiration date. So really nothing that you can really do with that except taking it to the court and litigating on that.
We have seen a very successful results in the court. In fact, we have seen that when anybody has gone against the administration to the court in this administration, we have seen a significant amount of resistance from the courts where they are resisting the administration because the courts also believe what we believe in, that the Trump administration is violating the law in delaying it, in denying it, and giving the shorter approvals. So applicants should be ready to take the case to the court. If they are not willing to, they will face a significant amount. According to the recent report given by the USCIS, they have had denials of approximately 25% of the H-1Bs, which is very significant. We do every single day, people coming to our office, they have been living in this country for 15 years or 13 years, their H-1B has been getting extended without any trouble, but now they got a denial. What do? So of course there are other alternatives when you get a denial, but people should be ready to go take to the court, and if you're not willing to, you will face significant amount of problems. On the H-1Bs and that we have seen recently, that some of the H-1Bs are getting revoked. What are the kinds of revocations that the USCIS does, which has already approved non-immigrant visas? What kind of revocations that they have?
There are 2 types of revocations. There's one where the employers will withdraw the H-1B approval, and the other one is a revocation based on fraud. And so there are some instances where there are certain petitions filed for what we call in-house projects that aren't really a legitimate or genuine job opportunity. So in those cases, USCIS after some investigation, will eventually revoke the H-1B approval, and that has really big consequences because that person will effectively be out of status because that initial H-1B approval will means that they being revoked will mean that they haven't been counted against the cap and therefore are now out of status.
So are you telling that, let's say for example, if some company has filed an in-house project H-1B, which we doubt some of those in-house projects, and if they have moved from that company to a company B, will they still be in trouble if the the in-house project is revoked?
Yes, so that first approval with company A, once that gets revoked based on fraud, you're no longer counted against the cap, you're automatically out of status, so you have to plan to leave the country immediately.
So all the subsequent H-1Bs are also revoked,
right,
because they're always counting on the first H-1B which was filed in-house. We advise people, those who are filing for duplicate applications and those people who are filing in-house, which, doubtfully in-house applications, please do not do that. You will face a long-term problem. We have noticed significant amount of cases that are getting revoked. These cases that have been filed in 2016 and 2017 are getting now revoked, even though they might have moved out of that company and might have already extended a couple of H-1Bs, even if subsequent H-1Bs are genuine H-1B applications, because your first H-1B might not be a proper one, all your life you're going to struggle because you will be considered to be out of status because you're not counted towards the H-1B properly.
Yeah, and I will just say, keep in mind, it's like a domino effect, that once that first domino falls, everything else
right.
falls.
So what she's saying is that if, we have noticed that some of the companies that are filing many in-house projects, if one H-1B is revoked from that company, they're going to revoke all the in-house projects from that particular company. And we have seen that domino effect very significantly. In some cases, 200 to 300 H-1Bs have been revoked for one company. And that happens especially when they do file in-house projects, when the in-house projects that we don't consider we don't consider them to be legal, though. Now, the burning question, V, is the quota. Now, your team has filed a lot of H-1Bs in the April of 2019. How many master's quota, are we still expecting anything in the master's quota right now?
We think we will be receiving some. Right now we've had about 65% of premium master cases already received, and about 55 non-premium masters cases received.
So are you telling that there is a 10% difference between the premium and non-premium,
right,
and still there are receipt notices that are still trickling in?
Yeah.
For the regular quota, for the masters in the regular. So because there is a 10% difference, you're expecting at least 10% more receipt notices to be received in the master's quota. What about in the bachelor's quota? How many have you received in the premium processing? How many have you received in the regular processing?
For both, we've received about 10%.
Okay.
But then again, it could be because we're not filing as many bachelors as we are a master's cap.
Okay, so we may be expecting a little bit more in the premium processing because based on the percentage, it looks that at least 25% should be receiving receipt notice. So we might be expecting. So bachelor's quota is a little bit behind in getting the receipt notices as compared to the master's quota. So you may be expecting a little bit more coming in. In the regular processing of the master's quota, we do still expect approximately around 10% of the people to still get the receipt notices. They are still trickling in a little bit. So we may be getting in probably this week and next week also. In the past 3-4 days, I don't think so we have received any premium processing in the master's quota.
Right.
So that may be, in the past 2 weeks, we have only noticed one receipt notice in the premium processing. So that may have stopped as of now. It's not official, but that may have stopped for the premium processing. For the regular processing, there is still hope that you might receive it. On the premium processing, did you receive any approvals or RFEs on the new quota?
For the new quota, not yet.
Not yet.
Yeah.
No approvals, no RFEs as of now
No.
yet. Even though it's premium processing, they're saying that the premium processing will be considered on May 20th or June 18th? May 20th. May 20th. From that time, the 14 days will count. So we have not received the RFEs or the receipt notices. We may be expecting it pretty soon. Most probably when they say May 20th, they may even delay it. But at this point of time, May 20th is the day the premium processing starts. For those people who have not converted into premium processing, we are expecting that the USCIS will open up on June 18th or so. June 18th, they will be allowing us to file or convert the existing cases into premium processing. So if you were to convert the premium into normal, you may not be allowed right now, but you may be allowed once the June 18th hits in. Now, from March 1st onwards, the USCIS has implemented a new system where for all the I-539 applications, that means for those L2, F1s, and H4 applications, they started the fingerprinting. That means that every applicant, before the application is approved, they must be fingerprinted, and they forced us to pay the extra $85 fees. Now, the main question that pops up, is that when you file a H1B and a H4 and EAD, normally when we are doing this, we used to get applications approved at the same time.
Right.
We used to file the H1 application in the premium processing, and then we used to get the H4 and EAD to be approved at the same time. What is happening right now with the new fingerprinting rule?
Yeah, so just to correct you, it was March 11th when the new I-539 biometric system came out. So lately we have seen that even though the H1B, H4, and H4EAD may be filed concurrently, the H1B may get approved in premium processing, but the H4 and H4EAD is still being delayed due to the fingerprinting requirement. So, I mean, thinking about strategies and how to adapt to this new requirement, we're taking a stance that perhaps it is better to file, the H1B and H4 and H4EAD concurrently without premium, and then once you get the notification for the fingerprint, it's taken about 20 days to get that completed, then wait for that to happen, and then upgrade the entire thing into premium processing. So perhaps that would expedite the process overall, but for now, even though they're filing together in premium processing, they're not even getting that 15-day benefit.
Yeah, so we will update this in the coming Facebook Live and YouTube Live. As of now, for those applications we filed in premium processing on or after March 11th, we have not received a single H4 approval as of now. We also will update you in the next. We thought that we would get some results by this time. We would update by this week, but we didn't. Please tune in for the next week. Then we'll give a results with regards to how the H4 and H4 EAD. And this is going to affect 100,000 plus people who are on H4 EAD, especially if their H4 EAD is expiring and you're filing in premium processing. You may or may not be getting the benefit of it. This is a very great disaster. As we has pointed out, that it's probably for those people where the H4 and EAD, if they are not going to approve in the proper timing by the time the H4 EAD expires, you may want to litigate it. And she has segregated one and probably assigning 2 lawyers within her department for the litigation purposes because of these delays. Certain things, they cannot be solved with premium processing. For example, H4 EADs cannot be solved with premium processing. There are a lot of delays that this administration is doing intentionally just to suffer. I mean, there is an old legal theory that says that delay in justice is considered to be denied. That means justice delayed is justice denied. And in H4 EAD cases, we are noticing that they're purposefully doing it other than you going to the court. I mean, there's no other option if they don't approve the cases in the premium processing. You may want to consider that. Some questions live on Facebook and YouTube. I have this question from Shivam from YouTube. He's asking a question, whether the employee is legally bound to provide the LCA copy to the employer is legally bound to provide the LCA copy to the employee. Shivam, yes, the employer is legally bound to provide the LCA to the employee. They are supposed to, if they do violate it, it's a dual violation. They might face a very dire consequences if they don't provide it to the employee. One other question I have from Shivam, the same. Hi, Shivam has good questions today. He has his I-140 approved and it's been approved for more than 180 days. Can he file when he is joining company B, even though his I-140 with his company A? Can he file an EAD along with the H-1B of company B? Shivam, the answer is clearly yes. You can file for your wife's H-4 EAD along with your H-1B, absolutely no problem.
Kushal from Facebook Live has a question. His H-1B was upgraded to premium, but you haven't heard any results yet. I've actually had 2 cases this past week with that same scenario where we filed early in April and they still haven't received any notices, any receipt notices. So just kind of be patient, wait to see if the cash will be checked and it will be receipted soon. We think that it's delay from Quota. You know, they're kind of backlog on getting the receipt notice for Quota, so maybe they haven't had time to issue the receipt notices. But right now, there's nothing you can do if your receipt notice hasn't been issued yet, because there's no receipt number to follow up on yet.
Jitendra has this question that his wife is an L2 EAD. It's been 65 days. And if it crosses 90 days, can he apply for the interim EAD? Well, that rule is there on the books, but I have not seen any interim EADs issued by the USCIS. And these are the things that maybe you should go to the court. That's the only solution that I can think about where you can get an EAD. Right now, if it's just an L2 EAD, not L2 extension, it's taking approximately 100 days nowadays to adjudicate the L2 EAD.
Chavi has a question from Facebook Live. His H-1B change of status is in progress. Can a person travel outside the country for an emergency? I mean, if it's an emergency, that's up to you. But the implications of traveling while H-1B change of status is that you'll abandon the change of status request. So if you leave, your I-94 won't get approved, your change of status won't get approved. And then if the H-1B does get approved, you'll just have to go for consular processing to get a visa stamp.
Questions from YouTube. Here, his H-1B is expiring on June 14th of 2019. He filed an extension application. While the extension application is pending, can he transfer to company B? Will there be any consequences because an extension application is pending? Here, since your I-94 validity is still there until June 14th of 2019, you can file for the transfer application, no negative implications because you have an extension pending. If your I-94 would have expired, it is a completely different story. I would have recommended you to stay until your H-1B extension is approved. But now, since your I-94 is valid, you could move to company B. The transfer is not a problem at all.
Upper Team has a question on Facebook. He's currently on STEM OPT and he plans to apply for H-1B next year. So it sounds like you still have status OPT STEM until June 2020. Could you apply for H-1 application? Yes. Obviously, you can apply for the quota for the lottery in April and still continue to work on your STEM OPT until June 2020. And then when that expires, assuming you've timely filed your H-1B petition, you'll be granted that automatic cap gap extension.
Surav has this question. His H-1B has filed in the master's quota, and he didn't said whether it's a premium processing or normal processing. He hasn't received a receipt notice yet. What are the probabilities? I think so. If you have filed a premium processing, I would say your percentage of chances is 1 to 2% for you to get it. If you have filed in the normal processing and you still did not receive it, this is our guess. You have about 10% probability of still getting in the lottery. That's our guess. I mean, based on the numbers that we have.
The Neil's question is, can a person work on an H-4 EAD extension while it's pending? No, you can only work on your H-4 EAD pursuant to that card. So you must have that EAD card in hand in order to work.
Surabha has this question, what's the date where we can say at which point of time where we are not going to receive any more receipt notices? We're expecting that somewhere in the end of May or early part of June, we will declare at that point of time that no more are expected though. But as of now, you still have a chance. You can expect it for the lottery for this year.
Vivek, your question on Facebook Live, how much time is it taking for H-1B and an H-4 EAD filed concurrently taking? We kind of mentioned that earlier in the beginning of Facebook Live. Even if you're filing it concurrently in premium, the H-1B could still be approved within premium processing time, but the H-4 may be delayed due to the biometric requirement.
And the processing time for the H-4 EAD, if you have filed in premium processing, at this point of time, we are unable to guess it. We don't know whether they're going to consider in the premium processing. Please tune in for the next week because we don't have a stats at this point of time. But if anybody who have done the fingerprinting and you got your H-4 and EAD, please post it in our Facebook and YouTube, and we will call you to make sure that we verify the information so that we can pass the information. As of now, for those people whose applications have been received by USCIS on or after March 11th, we have not any single report where the H-4 and EAD has been approved. Jyoti has this question. Her daughter has filed a green card application for her, assuming that her daughter is about 21 and she filed under the immediate relative. How long it's taking for the interview notice to come in? And her application was being filed in September 30th. I'm assuming September 30th of 2018. It's taking approximately 16 to 17 months for an interview to be coming in. But I have to tell you, Jyoti, some good things is that there are some cases where they're not interviewing the parents of the US citizens. In fact, I had one case that got approved today where we have filed, the daughter filed for the father. It was approved without an interview. It is possible for the immediate relatives, especially only for the parents though, not for the spouse, where they may not interview you completely, they may give a green card. But if there is an interview, we're expecting it in approximately 18 months since the time of filing. And since your case is filed in September, so you can expect somewhere in January or February of 2020 that you may be expecting an interview.
Vignesh has a question. Can you file an H-1B transfer to company B and C while there is an RFE pending with the company A? Yes, you can file a transfer to another company while your amendment is pending with company A. But be sure that if you're filing that transfer, that is a bona fide job opportunity. So, I would say pick one, company B or C, and go with that to make sure that that's a legitimate, bona fide, and genuine job opportunity. But yes, you can file while an RFE is pending with company A.
Yeah, but one thing I'm a bit worried about is if the I-94 is expired with company A, then going with company B and company C might not be a good option, because company B and company C, they will wait, the officer will wait until company A's extension is approved. If the I-94 is valid though, I don't see a problem. It's just the I-94 validity.
That's a good point. Saeed asked, there's H-4 been approved, but the H-4 EAD application, which was filed separately, is still in progress. Is there anything that you can do about that? Unfortunately, no. H-4 EAD cannot be upgraded to premium. So the processing time, I think, is still from 12 to 15 months, so you just have to be a little more patient.
Rag from YouTube has a good question that, what are the statistics for the MTA and MTR? What he meant to is that motion to appeal and motion to reconsider. According to the USCIS, motion to, when we file an appeal, you have less than 3% chances of getting approval. They don't release the motion to reconsider statistics, but I would say the chances would be around 5 to 10% for you to get anything done in the motion to reconsider. we are looking at is that when we are filing, our office is filing the cases, instead of doing a motion to reconsider or to file a motion to appeal. Now, motion to appeal and motion to reconsider, and sometimes, for example, if you are filed a transfer or extension, you cannot continue working at that location if it's been denied. The better option probably would be to file a court case, which we have started this new department. And we've been doing that litigation. It's not new for us, but we have now expanded. Now she has allocated one, and she's trying to allocate 2 lawyers just for the litigation purposes. In fact, one of our lawyers has just went to DC court 2 days before. So we would recommend that in the cases, you may want to evaluate yourself better if the motion to reconsider, especially when I am telling you the percentage is less than 5% that you have approved, you may want to choose to go to litigate rather than actually going to motion to reconsider or motion to appeal.
Arun has a good question. So thinking about RFEs as they start to come up, as these quota cases start being issued, RFEs, what we really emphasize with third-party placements is that client letters are very important, and that goes to kind of prove the work arrangement and the availability of specialty occupation work at that third-party location. But the question is that what happens if the client letter can't provide an client letter? So there are also alternative documents that can be submitted, although they don't provide as much credibility as the end client letter. There's always supporting documents like ID badge, affidavits, and others, evidence that the attorney can always help you with if you get that kind of RFE.
Atnu has this question. His L1B is expiring in 4 months. I'm assuming that is the 5 years L1B expiration in 4 months. Can he upgrade to the L1A? And I'm assuming that he want to use the 7 years because L1A has 7 years, L1B has only 5 years. The answer to the question is yes, you can. However, it all depends on whether or not the previous position that you held outside the country is a multinational executive position, and the position that you're going to work in future on L1A is a multinational executive. But the simple answer to your question is yes, it can be done. Question from Santosh: when can you expect a regular cap H1B application receipt notices? I think so. We did receive good number of them. I mean, we have about maybe 50% of the total receipt notices we are expected to receive. We received it. We may be expecting 50 more percentage. I'm expecting them to trickle them by end of this week, or probably by next week. We should be able to get the receipt notices.
Manasa had a question that says H1B, which was filed in premium processing, got picked. And how does one know whether or not there's confirmation on that? Usually with the premium processing selection, it is email based. So if your employer forwards you an email, that will confirm that it's premium. And when the receipt notice gets issued, in the description in the middle of the body, it'll say premium processing unit.
Abhilash has this question. His wife has a felony of assault. Does it affect filing for his green card application? No, it won't affect your green card application. Obviously, for your wife, it will affect her green card application. I would recommend definitely to contact a lawyer about what complications will be for your wife. But as far as you're concerned, your green card has nothing to do with her. That's a felony for her. That has nothing to do with you. You could still be fine.
VJ has a good question. He has an H-1B approved for location A for 3 years, and then an amendment was filed, but it got shortened to just a year approval. Now he's wondering which I-94 is valid. So our strategy sometimes is that because the underlining approval, the 3-year one, is still valid, you can still use that I-94 and come in on that. And if any other amendment is required, you can amend based off of that 3-year approval notice.
Abhilash has this question, his follow-up question. His wife is actually a U.S. citizen who has a felony conviction. I'm assuming that your wife is going to file an application for your green card. We need to check very thoroughly what the felony conviction is. If that has any implications on the entire application, you may want to check with your lawyer. This is not a perfect forum for you. It's not a very generic question that we can answer here. You may want to check with a lawyer, sir.
A partner has a question about his H-1B extension, which is valid June 10, 2019. An extension was filed in premium, but then an RFE was issued, which has a due date of August 1st. So his question is whether he'll be out of status after his I-94 expires. The answer is no, because you're in a period of authorized stay. So because you filed the extension timely, which is before your expiration date, having an RFE will not, cut that off. As long as that is still pending, you'll be in a period of authorized stay, so you're okay.
Jitendra has this question. After his L1B or L1 term has expired, can he work on a day one CPT enrolling in a master's degree? Here is the answer to you. No, the answer is no. We do not recommend people joining the universities that are giving day one CPTs. In fact, 2 of the students from the Campus Billy University were been deported recently. We have published an article on rnlawgroup.com. I want you to read those articles on the day one CPTs. So please read those articles on those. Remember that the F1 student visa is not for a work visa. Especially, you cannot work while you are studying. Of course, you are allowed to work on an OPT and the STEM extension. At that period of time, you are definitely allowed to work. But while you're going to college, if you are working, and if the purpose of your going to college is to work, that itself defeats the purpose of the student visa. Student visa is given for the students to come and study in the United States, not to work. H1 visa is a work visa, L visa is a work visa, F1 is a student visa to go to school. Of course, to enhance the degree. For example, if somebody does a law, if they don't work for a couple of years, the law degree doesn't have that much value. So that's the reason why they did create an OPT. That's a reason for STEM people, they have created a STEM extension where it allows you to work. But if you're going to work at the time when you are going to school on the day one CPT, we consider that as a clear violation for the student visa. They are deporting a lot of students. I want you to check an article which we published this week in rnlawgroup.com.
So to piggyback on that, Jignesh has a question. So what do you do after you're not selected on H-1B? What kind of options do you have?
Well, certain times you may not be left with any option. I don't want you to risk and stay and work here in the United States. If you are not selected in the, and you have an OPT, you have a STEM extension, and you are not selected in the H-1B, you may go back to school if you want to learn something else. That's up to you. You may go back to your home country and try your luck again on the H-1B. Even if you go back to the home country, you can always come back on H-1B under the master's quota directly from India if you have a master's degree from United States from an accredited nonprofit organization. It's up to you. If you're eligible for H-4, that's another option that you can consider. You may consider doing doctorate degree, that's up to you. But day one CPT is not a good option. We've been recommending not to. We have had a lot of issues. We had University of Farmington, that was been an issue for the day one CPTs. We had Silicon Valley University that went into trouble. We have Tri-Valley University that went into trouble. We have University of Northern New Jersey that went into trouble. At this point of time, out of the 8,000 or 9,000 educational institutions, we only see 7 or 8 institutions that are issuing day one CPTs, and we do doubt that those institutions are legal. These institutions are issuing the day one CPTs. They don't have any admission criteria. Anybody can apply and get it. There is no requirement when the education will start. They can start in August, September, October, any month that you want to. And most of the students that are enrolled in these universities happen to be on F1 student visas. I mean, that's not the case in University of Houston that we both went to, or some other universities that we go. So these are the universities, these are the mills that they have started for giving a work permit. They are violating all laws. A lot of people ask this question: when the university is violating the law, why should I be worried? University should be worried. No, you as an individual have to take the responsibility of your visa. Even if somebody tells you, even if the President of America comes and tells you to do an illegal act, you will be put in jail just because you acted. You need to have your own judgment call. If the university is giving a wrong thing and you're taking it, You are responsible for it. You cannot leave all the responsibility on the university. The university might be punished, that's a different issue, but you'll be punished. I want you guys to be very careful, and this might affect your long-term staying in United States. In fact, recently there are a couple of people who are from University of Farmington. They have got their H-1B visas approved. They were once on a University of Farmington. They got their H-1B. They went to India. They got their stamping. When they were trying to enter into the San Francisco airport, they were being denied entry. They were being put on a 10-year bar for misrepresentation. So I want you to be careful when you're trying to join. When you see that there is no hope, the only hope is day one CPT for you to work, please don't pick that option.
Kushal has a question. He has an I-797 receipt notice for his quota cases that has been selected. So where do you go to monitor your status? There's the case status online at uscis.gov. And you can look at that and see where it is. And when a case is saying it's being adjudicated, it means that it's with USCIS. An officer is deciding whether or not to approve or deny your case.
I converted L1A to H1B. Can my current employer file a green card under EB1? EB1? Yes, if you qualify for that, they can file, even though you're on H1B, they can file under EB1, but it's very limited circumstances. First question that comes to me is that if you are on L1 for such long period of time, they never filed under EB1, how come they are going to file right now? That's a doubt that I have on your company, sir. At the same time, the company that you are on H1B should be same company that held you, the L1. If it's a different company, no, you cannot file EB1 with a different company that whose branch office that you never work back in your home country.
Rahul, I have a question for you. Under a person filing for perm filing, they can't get an experience letter from a previous company. What can they do? Can they get it from a colleague? Will USCIS accept that?
Yeah, we have written 2 articles in our business partner, which is immigrationgirl.com. I want you to read those 2 articles. We know some of these not so good companies that don't give any experience letters. There are alternatives. You can get the experience letter. You can get the colleague write a letter to you. You can provide the pay stubs. You can give the appointment letter. You can have any of the proof that you have worked with that company as an evidence that you have experience. I want you to read the article at immigrationgirl.com, especially when we do file for the I-140. The USCIS requires the experience letters, but there are alternatives when the experience letters has not been issued. Sometimes we have even used that when that the person has resigned without giving 4 months notification. In some of the countries that they use 4 months you have to notify before you leave a job, and they are not willing to issue an experience letter because you didn't issue 4 months notification. So they sent that email to us because since you did not give a 4 months notification, we are not going to give you experience. We use that as a part of the experience letters. So there are different creative ways that your lawyer can work with you if you're not getting the experience letters. And any communication with the HR also can be used, and your emails, any printouts that you have, appointment letters also can be used as a substitute for the experience letter. Can a U.S. citizen, Sheila has this question, can a U.S. citizen sponsor GC for the older sibling? The answer is yes, you can file for the older sibling. The waiting period is approximately around 20 years. I don't know if you want to wait that much, but yes, a U.S. citizen can file for older sibling. That means older than you can file it, absolutely no problem. The kids also can come into that. However, the kids have to be under 21 at the time when they're receiving the green card. There are certain age deduction that can be possible, but overall they have to be under 21 or nearby 21. So if you're filing for older siblings, if their kids are 10-year-old, most probably the kids are not going to get the benefit. So you may want to see if you really want to get your older sibling.
Chowan has a question about his 240-day limit. So as a reminder, 240-day rule only applies to a pending extension. So meaning you can't work beyond your 240 day after the I-94 expires. So a strategy that you can do is to file a second extension before your 240 day to extend on that 241st day onward so that you can continue to have work authorization. Really, that's the only thing to do. Otherwise, you need to stop working.
Durai Swami has this question, why, this is for you, why is that there is a lot of venting right now on the H-1Bs?
For just in general?
In general.
I mean, I think a lot of the questions coming about is because Quota was all happening and
no, the question here is more about why is the administration so much?
Kind of cutting down on the H-1B. I mean, with the Trump Buy American, Hire American, I think this is the easiest target to kind of narrow down immigration.
Yeah, the Trump administration thinks that H-1Bs are a drain to United States. I mean, this is not official what I'm speaking about, but that's what they have intention. The administration has hired people that are completely anti-immigrants as the USCIS authorities and also in all the top DHS top positions. So the Numbers USA people, FAIR organization, these are the organizations that are more anti-immigration. The administration came into power using the stance of anti-immigration, and they're using that to vent against the H-1Bs. And that's where we have seen a 25% denial rate, is an unprecedented denial rate. Though, you know, it may be good for some of the countries like India, because when I went to India 2 weeks ago, there are a lot of companies that are opening there because they couldn't find employees here. They're moving the jobs there, but this administration is unable to understand that concept.
Vanil has a question about H-4EAD extensions. How early can you apply for it? You can apply it as early as 180 days.
That's right. But however, I have not seen a single rejection yet if they have applied way earlier.
Okay.
So I would apply. I mean, I have not seen a single. If you are eligible for a H-4EAD and then it's not expiring in even 1 year, but your H-4 or your husband's H-4 H-1 approval is there for 3 years, I would apply right now. Irrespective. I've not seen a single denial because the person has filed earlier enough. So though it's a requirement that you have to file within 180 days, we have not seen a single denial. I'll go and apply if I were you. Yeah. At the most, you're risking the filing fees.
Yeah. So. And you never have to wait for the H-1B extension to be filed along with it. You can file an extension for an EAD standalone, regardless of whether the H-1B needs an extension.
Is there any update on the H-4EAD? No update, fortunately. No update on H-4EAD. You can still continue filing for the H-4EADs. Absolutely no problem with it. You can still do it. No update on that right now, sir. Too many questions on the quota. Still, as we said, about 10% of the masters are still not been receipted. Approximately around, I would say about 10% of the bachelor's quota has not been receipted at this point of time. So please keep the hopes up, and let's wait until about 2 weeks. We may then at that point of announce that no more receipt notices are coming. But at this point of time, you still have a slight chance of getting the receipt notices.
Rakesh has a question about the timeline for USCIS to adjudicate an RFE response without premium. It's kind of taking about 3 to 4 months after the RFE response has been submitted. However, if that's too long, you can always upgrade your case to premium.
How early can a H-1B extension can be filed? This question is coming from YouTube.
Yes.
His H-1B is expiring in January of 2020.
So you can only file 6 months before the expiration date.
So that will be July of 2019. You cannot file before that. Question that comes from Saurabh is that can a F1, F2, H1, H4 person start a company? Here is the thing though. To own a company is different than starting a company. For example, if you buy a stock in YouTube or Facebook, that's where you guys are right now watching. You can. You're owning the company of Facebook, or you're owning the company of Google, which owns the YouTube. You can own the company by stocks. But if you are starting a company, that means that you are doing an entrepreneurship here. You're actually contributing to the company development. You're actually working for the company to develop. that is where you need to check whether your work visa will allow you or not. For example, if you are an H4 EAD, we don't have a problem. H4 EADs can do anything they want to. H1s cannot work to start the company unless the work, the job description and all those things, which you have to check with your lawyer before you do anything, allows you to do it. Mostly they won't allow unless you're working for a law firm and then you are forming a company. That's a different issue though. So I want you to check if your work permit will allow it or not. H4 EAD is definitely no problem. H1B, yes, there is a problem there. F1 visas, yes, you need to check with your lawyer on that. F2s, no, you cannot start a company.
So is an F1 visa stamp required for applying under a change of status for H1B? Well, if you have a valid STEM OPT, you should be fine filing a change of status for H1B. The only time you need a valid visa is that when you're traveling to come back in, you need traveling on F1 and coming back in on F1, you need a valid F1 visa stamp. But if you haven't traveled before filing for your change of status, you don't need to get an updated visa stamp in order to file for a change of status.
Duresami has this question: if the H1B has been denied and the I-94 has expired, do they have any grace period for them? Mr. Duresami, there is no 60-day grace period available here because your I-94 expired. So I would recommend that under these circumstances, the person should leave as soon as possible. Now, I'm not telling you, I will just tell what I would do under your circumstances. If the denial comes today, will I fly today itself, buying a first-class air ticket, leaving everything out and leave? I won't do it. I'm not telling you what to do, but I'll tell you. I will leave within 2 weeks, give the power of attorney for all my other belongings, and then I will pack and leave within 2 weeks. I won't leave it. But if the I-94 expired and unfortunately you don't have much options, that's the reason it's essential for you when you're filing applications, make sure you get a decision before your I-94 expires, because once your I-94 expires, your choices will be very limited and most probably just nothing other than leaving the country. But if your I-94 has not expired, you will have a lot of different options that will be available for you if your I-94 expired. There is a video presented by the colleagues of we in our office, by Stephen and Justin, about timely filingness is very important for the H-1Bs. So you may want to get the decision before your I-94 expires.
So question of what are the chances of an approval if the I-94 already expired and there was an RFE issued? So it really depends on the type of issue that is in your RFE. Assuming that you've timely filed your extension before your I-94 expired, you can still get an approval with the I-94 attached to it. So it really depends on how you're responding to the RFE, the type of documentation you're providing in order to get that approval.
A question that comes up: what are the options for the nurses to come and work in United States from India? I have to say that the limitations is very less, not much options there for the nurses to work in United States, because the H-1B requires that the degree is a specific requirement. And normally for nurses, it's the 2 years associate degree that is required, not a bachelor's degree. Of course, the nurse practitioners requires that they must have a specific degree in nurse practicing. Now, that's very tough to get a license from India for regular nurses to get the clearance from the, what is that called, the nursing. There is the clearance authority for the nursing authority where they need to get it clearance, and they need to get the licensing requirements. They must complete all the paperwork for license. Previously, there were some success cases in the H-1B, but nowadays none, zip. However, there are 500 H-1Bs that are allowed for a non-profit organizations. There are about 40 or 50 organizations that are allowed to file for these 500 nurses. That's the only way that you can get the nurses on H-1B here. There are 500 visas that are available. Other than that, no. There are some limited exceptions available if the nurse is a Canadian national or a Mexican nationals. There is another visa called TN visa that doesn't have any numerical limitation. even though degree is not required in this particular instance of a TN visa, you can bring them on a TN visa, but they must be the Canadian or Mexican nationals to bring them on a TN visa for nurses.
So there's some questions on H4 EAD. Can a person work and study while they're on H4 EAD?
Absolutely.
Yeah.
If you're on H4 EAD, you can work and study, no problem with that.
And there's no limitation on which company you can work for while
Yeah,
you're
you
on
can be a
H4
Microsoft CEO like Satya Nadella, or you can flip a burger at McDonald's. You don't have any limitations on H4 EAD. You don't need an client letter, you don't need vendor letter, you don't need a lot of filing fees and a lot of lawyers fees. H4 EAD is fairly more simple than compared to the H1B. Absolutely no. Do you have to work on H4 EAD? No, you're not forced to work on. You can take the H4 EAD and not work. That's fine too.
Now, are you forced to work on H1B if it gets approved?
Yeah. If you don't
Yeah.
work, you are violating. The only
Yeah.
purpose why you are living in this country is to work for that given company. If you're not working, you will have to leave the country. Gaurav has this question, my H1B is approved, my H4 is still pending, is it a common? I'm assuming that you might have filed this application after March 11th, so I want you to go back to the previous video recording of this one. You will have some hearings on that, why the H4 is not getting approved at the same time as the H1B. You may also want to check us with the next week. We may have a better update than what we have today. Here is the question that came out on the YouTube, is that he's tried to move from H1B to R1. The R1 has been denied. Can he still continue working on the H1B? Absolutely. Your H1 is still valid. You can still work for the company. Just because your R1 visa has been denied, that's perfectly fine. You can continue working on the H1B. Well, too many questions. The time is getting up. Why is the I-130 taking so long to get approved? Overall, since this administration has come into power from January of 2017, the processing time has doubled, and this administration has no intention to bring it down. Believe me, no intention to bring it down. And that's the reason why the I-130s are taking longer than the previous administration to get it approved. Pradeep has this question from YouTube. He has H1B approved. Can he do one more master's on the side while he is working? Absolutely, no problem. You can do master's on the side while you are on the H1B. I don't see a problem at all.
And Deepak has a question about an extension pending, and the statement of work was submitted at the time of filing, but now it expired. So what do you do? Hopefully, at that time where they're adjudicating, that will be enough. If not, they'll issue an RFE for you to provide more documentation. What
if they approve it with the pre-X date?
That is very likely. You could get an approval with a shortened date based on that statement of work.
Can he, at this point of time, go with the extension and submit it to the USCIS without getting an RFE?
With the shortened SOW?
No, he has now another. Let's say he got an extended SOW.
Mm-hmm.
Can he submit to the USCIS right now?
The only way you could do that if you haven't filed it in premium, you're upgrading it in premium, you can possibly submit the new extended SOW with the premium processing, but that's going to be up to USCIS's discretion to include that into your petition.
What the USCIS sometimes are stating in these situations where we're submitting it along with the premium processing is that, well, you didn't have the job at the time when you filed the application. I mean, they're using every possible excuse for giving a shorter duration. So there is actually a court hearing in the federal court on May 9th. We are one of the people who worked behind on this one. And this is a court hearing that is going on, hopefully so that we will get a decision where the USCIS will be restricted to give the H1B approval until the authorization period that you have. For example, if you have a 6-year period and you apply for the H1B and you are within 6 years, they may be forced to get the 3-year period. We are expecting a court decision soon. The hearing is there on Thursday, that is on May 9th in Washington, D.C.
Priyanka has a question about traveling to India with the visa, F1 visa valid for 20 more days. You can still use that visa if you're coming in before
Yeah.
that 20th day. But
Yeah, but I would recommend a
Yeah.
lot of caution because what's the purpose why you're coming into United States? If there is any violations, they will look into very closely. I would check with a lawyer if there might be any OPT, STEM, and if you have complied with every regulations that's there. We have noticed a lot of scrutiny at the airports, especially if you have only 20 days left. Legally, the answer is yes, but it's very tough.
practically, it's tough.
Yeah.
All the same questions.
Chai has this question on the YouTube. If the H-1B has been approved and it's just been less than 1 month, can he go for the stamping? Will that cause any problem because it's approved only in the past 1 month? No, I don't think so. That in general is a problem that you got the H-1B approval in the past 1 month. However, we have noticed a significant amount of 221Gs, unprecedented amount of 221Gs in the consulate where they're asking for additional questions. The whole purpose seems to be just to delay. Remember, delaying justice is denying justice. The reason why they want to delay is if you delay, you will lose the job. You lose the job, you'll withdraw the H-1B. That's how this administration. So be careful when you are going outside the country to get stamping. Be prepared to stay there for a couple of months.
Now, Mehabu has a good question. So his I-94 is expiring, but when he traveled, the I-94 was issued shortened based on the passport validity date. So how can he fix his I-94 when he has a renewed passport?
This is a very common problem. In fact, every week we do 2 of the consultations that I do is the I-94 has been shortened because the passport is expiring. I'm assuming that your I-94 is still valid. If you have I-94 is still valid, there are 2 ways you can resolve it. One is you can pay us a lot of money, we will extend your H-1B. That's one way of doing it. And it's a bad way of doing it. The other way is that you can buy you and your wife to go to Cancun and you can come back and you will given the extended I-94. I'm assuming that you might have already extended your passport by this time. Buy a Cancun ticket, go there. You don't need a visa to go to Cancun or any of the Mexican, those resort places, nice drinks and nice place. You go there, you spend the money that you spend on the lawyers, you go to their Cancun and then you will have a nice drink there and eat fish there. You come back, you will be given until the expiration of the H-1B. I suggest you to do the second option, cheaper, better, and no risk involved in it. Premium processing is 15 working days, 15 calendar days, 15, I would say 15 working days. But give it or take 2 days here and there. I want to leave it at 20 because the way you count it, the way we count it, it's different. The day it's been received is not counted, the day they approve it is not counted. So believe me, just count it as 20 working days for our calculation. Don't call your lawyer, don't call your employer. It's 15 days. The way you count, the way we count is different. I understand you are mathematicians, you count better than us, but right now you are under the jurisdictions of the lawyer and we count differently. The USCIS counts the same way we count. We don't want to count that way, but unfortunately we end up counting the same way, but the USCIS counts. Sheila has this nice question. My daughter is a US citizen. When can she file a green card application for me? 21 years, my dear Sheila, it's going to be 21 years. When your daughter turns 21, she can file the application. Based on the current scenario right now, if you were to file a green card application in the employment-based immigration, it's going to take 150 years for you to get the green card if you were to file today. So obviously the better option is the kids filing the green card. In fact, there are some people who have come here on H-1B, they went back to India, they came back, and now their kids have become 21. I have filed a couple of those people's green card application. Yeah, it is 21, it is not 18. The major in your word and your language is different. It's 21 years. Once the US citizen is 21 years, then they can file for their parents. And the process is fairly simple to get a green card if the kid is 21 years old. Any other questions from Facebook?
No. Josh, he has a last question. How long will it take to change status from H1 to F1? Usually that's not the case. We usually work with a lot of F1 changing to H1, but...
Yeah, here is the issue with the F1 visas though. There are two service centers, one is Vermont Service Center, one is California Service Center. Vermont Service Center is a good service center, but when it comes to the F1 visas, it's a bad service center. It's taking approximately 12 to 18 months nowadays to get any status to F1. The problem to move to the F1 status as compared to the other status, let's say for example H1 or H1 or H4, you have to maintain the status until your F1 is approved. So let's say for example, if you are an H4 visa and it's expiring in 6 months and you apply F1, if the F1 is not approved within that 6 months period, they are not going to approve your F1. So you may want to apply for the H4 extension again. In certain circumstances, you may have to file the B2 visa. It's called interim B2 visa, and then you may have to file a couple of extensions because every time you file a B2, it's only for 6 months. So F1 has become, changing the F1 status in the United States has become the toughest that I've ever seen. It used to be the simplest visa to apply a change of status 7 years ago or 5 years ago. Now it is taking ever. There are cases where we have filed F1 visas where I filed the F1 when the person came in on a visiting visa and they changed their mind, filed the F1 visa. We filed the B2 extension to maintain the status until the F1 is approved. And that status says that B2 was only for 6 months. We filed second extension. We filed the third B2 extension. All these things got adjudicated at the same time. A lot of expenditure, a lot of time they have to spend. So when you're moving to F1 visa, please be careful. Make sure that you consult a lawyer. Don't do it by yourself. Anything else? Thank you very much, V. Thank you very much for everybody for coming in, tuning in. For those people that we couldn't get to questions, you can come back to our daily conference calls, which you can get the details at rnlawgroup.com. Don't forget my business partner blog at immigrationgirl.com, and our supervisor in the H1B, if you want to make an appointment with her at any point of time, or any of our colleagues, you can check at rnlawgroup.com. Then you can go to the appointments. You can schedule an appointment to speak with her at